So let's move on to talk about health records as a legal document. Health records is generally considered a business record, and as such, the content within the record are admissible as evidence of legal proceeding. So legal proceeding, meaning the content of the health records, constitute as the healthcare organization's legal business record, right? So for health records to be admissible as evidence for basic principles, they must meet four things within this criteria. One, the first criteria is that the record must be documented in the normal course of business. The record must be kept in the regular course of business. The record must be created at or near the time the event occurred. And the record must be created by the person within the basis with knowledge of the acts, the event, the condition, and observation described in the record. So when the court has determined that the health record is relevant to a particular case, the judge will issue a subpoena or a court order to the owner of the record. A subpoena is a direct command that requires an individual or representative of the organization to appear in court or present an object to the court. So the advisory committee on the rules of civil procedures amended the federal rules to the civil procedures to specifically address e-discovery, or the discovery and procedure of the electronically stored information. So that pretty much means that we are used to being able to present information from a paper record, but what this says is that e-discovery will allow you to present information from electronically stored information. So morbidity and mortality reporting in the United States. This is it's maintained under the National Vital Statistics System, that is a federal agency that operates within the Center of Disease Control and Preventive, so the CDC. And the CDC is a group of federal agencies that oversees health promotion, disease controls, and disease preventive activities in the United States. So they try to ensure consistency of that data collection. The National Vital Statistics System provides standard forms and procedures. So the data collection forms are revised about every 10 years, and those standard forms include U.S. Standard Certificate of Live Birth, U.S. Standard Certificate of Death, and U.S. Report of Fetal Death. Morbidity and mortality reporting focuses also on the population-based statistics, which is estimates of the incidence of a disease as a percentage of the total population that could have been affected. Morbidity statistic calculation is the number, and this is what I talked about in the slide prior to this, is the number of people contracted the same disease during a specific time period, and the number who could have contracted the disease. So as we are going through this pandemic with COVID, this is what the CDC is doing, trying to track these particular this virus as it stands today. Morbidity and mortality reporting. Some of the common mortality statistics is crude death rate, neonatal mortality rate, post-neonatal mortality rate, infant mortality rate, crude mortality rate, cause-specific mortality rate, and maternal mortality rate. So morbidity statistics are calculated as an incident rate. And I just talked about that in the previous slide, is that the number of people who contracted the same disease during a specific time period compared to the number of people who could have contracted the disease. And then the incident rates usually include those race, gender, that particular data, so that the rates among different population can be compared. So let's move on to talk about management of healthcare systems. So CMS collects data from reimbursement claims in the national database. The database is the basis for disease related to effectiveness of health care delivery system and reimbursement system. Federal and state government use the data reported by hospital and other healthcare organizations to develop public health policies. So we're experiencing those type of public health policies today with COVID. So state laws and regulations establish legal requirements related to the form and content of health records for facilities located within the covered geopolitical area. So health record regulations are usually developed by the state administrative agency responsible for licensing healthcare organization. Failure to comply with state health records or public health records may result in a penalty such as forfeiture of a hospital operating license. They can receive a fine and criminal sanctions. The HIPAA privacy standards establish consistent rules that apply to virtually every healthcare facility. So healthcare professionals, healthcare information clearinghouse, health plans in the United States, they are all held accountable within those standards. HIPAA also notes the components necessary for a valid authorization form. So although many of these components, such as patient name and date of birth, have always been components of a valid authorization, HIPAA compliance make this a legal requirement now. And this hasn't always been the case. So the elements of that legal authorization must encounter some of these, and I'm just read a few. A description of the information to be used or disclosed that identifies the information in a specific and meaningful fashion. The name or other specific identification of the persons or class of persons to whom the cover entity may make the requested use or disclosure. A description of each purpose of the requested use or disclosure. Health records sometimes includes clinical data originally collected by other healthcare providers. For example, surgeons often supply copies of pre-admission laboratory test results of patients that's scheduled to undergo elective surgery. The process of disclosing health documentation originally created by a different provider isn't called redisclosure. So the federal and state regulation provides specific redisclosure guidelines. Most states have established regulations that address how long health records and other health care related documents must be maintained before they can be destroyed. For states that do not have stipulates or retention periods, then the statute of limitation for that state may be applied. So statute of limitation is a specific time frame that's allowed by a state or law for bringing litigations. Although the stipulation is 5-year minimum, many states require a longer retention period, and they can, and then the federal, of course, you have to take heed to the state laws. They take precedence over the federal laws. So that pretty much ends this part of our session. So please take a look at your chapter and review the content. All right. Bye.